So, my students, let's start a new session. And this time we are going to learn about the mediation process. And we already learned that mediation, arbitration, conciliation, all are different forms of alternative dispute resolution. And this mediation, we can say in a simple word that it is the most flexible and informal way to solve a dispute. And here the mediator will be a third person who is a neutral one, and he is the one who is appointed by the dispute parties. Now we will discuss this mediation in detail. So we said that arbitration, mediation, uh, um, conciliation, all these are different forms of ADR. That means alternative dispute resolution. And we already covered up the topic arbitration. So we learned that yes, when comparing it with the litigation means normal process before the court of law. So when we compare a litigation with arbitration is less expensive. It can finalize the dispute between the parties without no time or within a short span of time. So when we compare arbitration with litigation, yes, arbitration is less expensive and less formal. But when we compare mediation with arbitration, we can say that no, arbitration is bit complex, but the mediation is less expensive and less formal. But there is negotiation also. But when we compare this mediation with the negotiation, then we will say again no, mediation is not. Negotiation is the less formal way and less cheapest one. So this is a comparison between I just mentioned to know how each process is going on. And we can say that in arbitration there is award and it is binding on the disputed parties. But in mediation, the outcome of the mediation is not compulsory binding upon the parties like arbitration award. Even though the outcome is not binding on the parties while executing an agreement, they can enclose a mediation clause in that agreement. That is a valid process. See, yes. So students, now we will discuss the topic different types of mediation. In this video, we are going to learn about three important types of mediation. The very first one is evaluative mediation, then comes facilitative mediation, then the last one or the third one is transformative mediation. So first we will look it out what is evaluative mediation. As a term itself says evaluate. So here what the mediator is doing, he will evaluate the dispute matter between the parties and he will reach at a conclusion or he will reach at a fair and reasonable settlement between the parties. But here the mediator is very conscious about the legal rights of the parties. So we can say that he is playing moreover an advisor's role. When he evaluates the dispute between the parties, he learned about the merits and demerits of the cases or the strength and weakness from both the sides. He will convey this strength and weakness with the parties and finding and reach out to a better solution which is a fair and reasonable one protecting the legal rights of the parties. So do you know a thing that see most of these evaluative mediators will be lawyers. Why? because this evaluate mediator is need to protect the legal rights of the parties. He has to evaluate the dispute matter, and at the same time he has to reach out to a fair and reasonable settlement. So here, when a case or when a matter is referred by the court for mediation, the attorney connected with the case will work with the court to finalize the mediator, and probably he will be a legal expert. So we can say that most of the evaluative mediation, the third party or the neutral party, the mediator will be an attorney. And we will now look into this evaluative mediation through a better example. See, the matter is related with the custody of a child. See, the parents got divorced or the divorce process is going on, whatever it is. The dispute matter is the custody of a child. So the matter came before an evaluative mediation, and both the parents raised that no, they want the child's full-time custody. Father said, no, I want the full-time custody of my child. Then mother says, no, I want. So, but both of them neither wants to visit each other. So, what's the role of evaluative mediator here? He will study the matter and he will convince the parents with the laws of the land or laws prevailing in India, and he will have a discussion about the weakness and strength of each parties in this case, and again will convince these parties that what will happen if they go to the court with this issue. Thus, he reached out to a fair and reasonable settlement between the parties. This is the best example we can understand how a evaluate mediator plays his role or performs his role in evaluating mediation. Yes. Now we will look into the second option or second way kind of mediation, that is facilitative mediation. And this mediation was in existence since 60s and 70s. And here, like in evaluative mediation, here the mediator will not evaluate the dispute matter. He will not direct the parties. What he will do is he will only facilitate an opportunity to meet the parties and to have a conversation between them so that they can reach to a solution. So in a facilitative mediation, the mediator never makes any recommendation. He only advises the parties that yes, if you move to the court, this and this will would be happen. So we can say that in a facilitative mediation, the mediator is in charge of the process only, but the parties are in charge of the output or the resolution. And here also, like in evaluative mediation, we already learned that in evaluative mediation, the mediator probably will be an expert in legal wise. Here, it is not mandatory that the mediator need to be an expert in legal side. So now we will look into in which all areas this facilitative mediation normally happens. It happens in cases where the relationship need to be continued, like disputes between employees and dispute between parents. These are the two examples that we could relate with the facilitative mediation. So now we will move into the third one, that is transformative mediation. Transformative, it means there is happening some transformation. So we can say that it's a new concept. and it is basically depends on two values, that is empowerment and recognition. And the more interesting part is that during this mediation, there is a chance that the relationship between the parties may get transferred. Like the other two mediation, like evaluative mediation and facilitative mediation, here also, yes, of course, we need to find a solution that is there, but at the same time, this mediation also aims at changing the party themselves for a better life in future. Now I will explain in an example, so this concept will be clear to you. It's imagine that you are driving a car and the way is very free and it's a sunny day, and yes, your favorite song is playing, and you put your car window down, and suddenly you notice that the person, the next car is doing the same thing, and on the way you both were enjoying the drive, and yeah, past a smile in between. All of a sudden the situation changed. Something happened. One car suddenly slowed down, and after some time the car hits with each other. Suddenly the picture changes. You get confused, and many questions might have um, pop up in your mind, that what this, how did this happen, or do I have the car insurance, I renewed it, or is it expired, or where is my license? All these questions will suddenly take up your mind into a bothering mess, and you just want to blame the other person. That defense you will going to raise, that you totally confused that what you are going to do next time. You got suspicious, and you got a doubt in your mind that the other person will blame you, so definitely you will become more defensive. Then suddenly your mind changed. You will have a thought in your mind like, what is happening to me? See, we know that we all human beings are social animals, so we like to interact with each other, and yeah, we like to be open with each other, to consider others and everything. But when uh, something bad happened or a conflict happened, everything turned out. In appearance we may look so strong, but in a part, we the mindset, we may be weak, and we became so negative, destructive, and dehumanizing. But we can change the situation when we hear others, when we try to understand the situation the other person is going on, like when we empower ourselves and when we recognize others, everything became back to normal. This is transformative mediation. Then suddenly we become positive, constructive, connecting, and humanizing. Here, what we did, we used our inner strength to approach the other person very positively, understanding that person, and we started to talk with each other very politely, and we start negotiating, making decision together. So the situation looks so sound right now. This is transformative mediation. I think this explanation well made you aware with this concept. Now we will look into the process involved in mediation. So here the mediator will be a neutral person, and there is no any set of rules to conduct the mediation like this one have in litigation and to some extent in arbitration. And this mediation happens normally in three times, um, three situations like the parties may agree to go for a mediation before initiating a judicial proceeding. So the parties may enter into a pre-agreed mediation agreement, but there is no any law in India to regulate this pre-agreed mediation agreement. The second chance is that the parties may refer the dispute matter for mediation just after starting the litigation, means at the very initial stage of the litigation, and most probably it will be court referred mediation, and this there is law to regulate this process. This is regulated through section 89 of the CPC. And the third possibility is that the mediation may start uh, just before the trial or just before the stage of appellate, going for an appeal. So students, at last we will look into which all common matters are referring for mediation. It includes contractual disputes including money claims and dispute related with the relationship like disputes coming out from matrimonial cases and partnerships, and that disputes that related with the relationship but the relation needs to be continued, like the disputes between the employees, disputes between the neighbors, and etc. And lastly, the consumer disputes. So these are the common cases which we refer to mediation usually. Now the Supreme Court has mentioned out some cases which will never refer for mediation, and the Supreme Court held this in a landmark case, that is Afcons Internationals Limited versus Cherian Worky Construction Company Private Limited. And this case, the Supreme Court held that the matters like election disputes, criminal offences, and the disputes related with specific categories like minors, mentally challenged persons are excluded from the scope of mediation, means they will never refer for mediation.